Chapter 2, Real Estate License Law and Qualifications for Licensure. History and purposes of real estate license law, license categories, general licensure provisions, application requirements, sales associate license requirements, broker license requirements, non-resident license requirements, license information, registration, license renewal education. History and purpose of real estate license laws. History of Florida's real estate license law, purpose of regulation, important Florida real estate statutes and rules. History of Florida's real estate license law. In the 1900s, the Florida legislature determined it was necessary to protect public welfare by regulating the real estate industry. As a result, Florida put into place laws and authorities to regulate the licensings and practices of real estate brokers, sales associates, and schools in the state. In 1923, the legislature passed Chapter 475 and added it to the Florida statutes as the first real estate license law. Department of Business and Professional Regulations, DBPR. The DBPR was created and structured by Title 4, Section 20.165 of the Florida Statutes and is governed by Chapter 120 FS. Division of Real Estate, DRE. As a division of the DBPR, the Division of Real Estate provides all of the services necessary to administer Chapter 475. The DRE establishes both the Florida Real Estate Appraisal Board and the Florida Real Estate Commission. Florida Real Estate Commission, FREC, to further administer the license law and regulate real estate professionals. The Florida legislature establishes the FREC in 1925 under Chapter 475 and gave it to the authority to establish rules necessary to perform its duties. Purpose of regulation. The above organizations are covered in detail in a later section. When the Florida legislature determined that the public needed protection when engaging in real estate transactions, it put several regulations, laws, and rules into place for that purpose. The purpose of all Florida real estate regulations is consumer protection. Caveat emptor. Caveat emptor means buyer beware and signifies that buyers purchase properties at their own risk regarding the condition of the property. Florida subscribed to caveat emptor until 1985, when a buyer sued a seller for not disclosing the property's defective roof. Under caveat emptor, the buyer would have been out of luck. However, Florida Supreme Court ruled in favor of the buyer, thereby reversing Florida's use of caveat emptor. This ruling showed the need for further regulation in real estate sales and established that a seller has a duty to disclose known defects. As indicated in Chapter 455, Section 201 of Florida Statutes, this ruling and subsequent rulings laid out that a seller must disclose defects if all four of the following elements are present. The seller has knowledge of a defect in the property. The defect materially affects the value of the property. The defect is not readily observable and is not known to the buyer. The buyer establishes that the seller failed to disclose the defect. With caveat emptor, if the buyer asked, the seller was required to answer honestly. However, if the buyer didn't ask, then the seller had no obligation to disclose. With this change of regulation, sellers are now required to disclose defects in the property whether or not the buyer asks. Important Florida real estate statutes and rules. As mentioned earlier, the Florida legislature saw a need to protect consumers during real estate transactions from unethical and illegal practices such as fraud. Legislators also did not want to make it unreasonably difficult for an individual to enter into the real estate profession. Consequently, they established specific laws to meet these needs. The statutes are updated annually to create, amend, transfer, or repeal statutory material. Chapter 20 of the Florida Code covers the organizational structure of the executive branch of the state government. It is the statute that created the Department of Business and Professional Regulation and established the division within the DBPR, such as the Division of Real Estate. This statute also established the organizational structure of the DBPR. Chapter 475 is divided into 4 parts and provides regulation for brokers, sales associate, appraisers, and schools. Part 1 created the FREC, and includes its organizations, powers, and duties. It also covers regulations for licensure and brokerage practices, including violations and penalties. Part 2
provides regulations for appraisers. Part 3 is known as the Commercial Real Estate Sales Commission Lien Act and provides regulations for a broker's lien for unpaid sales commission. Part 4 is known as the Commercial Real Estate Leasing Commissions Lien Act and provides regulations for broker's lien for unpaid commission earned by a lease of commercial real estate. Chapter 455, or the Business and Professional Regulation. General provisions is the law used by the DBPR in regulating the professions under the department's auspices. It outlines the legislative intent in regulating these professions and includes restriction on deterring qualified individuals from entering any of the chosen profession. It specifically holds that the non-U.S. citizens may not be disqualified from practicing any of the professions regulated by the DBPR and covers the required qualifications to do so. Chapter 455 also includes the powers and duties of the DBPR and the organizational and operational requirements of the boards under the DBPR. This chapter covers general licensing provisions, education requirements, licensure examinations, and testing services, disciplinary grounds, actions, procedures, and penalties, and legal and investigative services. Section 455.02 provides guidelines for licensure of members of the armed forces and their spouses. Chapter 120 is known as the Administrative Procedure Act and provides procedures for government agencies to exercise their specific authority, including rulemaking authority, procedures, requirements, and challenges. It also covers licensing requirements along with disciplinary procedures and enforcement. Exemptions and exceptions from this act are also included. Chapter 61J2 contains the Florida Real Estate Commission's FREC rules. These rules cover licensure and education requirements, non-resident licensure, brokerage operation and business practices, trust fund handling, and disciplinary matters and procedures. Chapter 83, also known as the Florida Residential Landlord and Tenant Act, covers both residential and non-residential tenancies. It provides regulations for rental agreements, deposits, landlord and tenant obligations, tenancy terminations, and enforcement of rights and duties. Chapter 718 regulates condominiums and includes rights and obligations of the Developers and Owners Association. It establishes procedures for creating and selling and operating condominiums. Chapter 719 recognizes cooperatives as a form of property ownership and regulates the creation, sale, lease, and operation of cooperatives. Chapter 760 is the Florida Civil Rights Act, which created the Florida Commission on Human Relations with the intent of protecting all individuals with Florida from discrimination based on race, color, religion, sex, pregnancy, national origin, age, handicap, and marital status. Other state statutes regulate taxation and collections, construction standards, lien foreclosures, and tax breaks for undeveloped land used for agricultural purposes. In parentheses, Florida Greenbelt Law of 1959, in parentheses. The online Sunshine website provides access to these and other applicable Florida statutes. The online Sunshine website provides access to these and other applicable Florida statutes. License categories: broker, sales associate, broker associate. Florida offers real estate license that fall into one of three categories: broker, sales associate, and broker associate. A broker associate and a sales associate may be licensed as an individual or a professional corporation. A broker associate and a sales associate may be licensed as an individual or as a professional corporation, limited liability company, or professional limited liability company, if the individual has obtained authorization to do so from the Department of State. A broker associate and sales associate may not be licensed as a general partner, member, manager, officer, or director of a brokerage firm. A broker is someone who is licensed to perform real estate services for another person for compensation or the expectation of compensation. Compensation can be monetary or anything else of value. Real estate services include the sale, exchange, purchase, rental, appraisal, auction, advertising of real property, business enterprises or business opportunities, or the offer to perform any of these services. Services also include procuring sellers, buyers, leasers, or leasees. Although a broker may appraise property, such appraising does not equate to appraisal services that must be performed by a registered or licensed appraiser. The broker category of licensure also includes any individual who is general partner, officer, or director of a partnership or corporation that acts as a broker. Sales associate. A sales associate is someone who performs the same real estate services as a broker, but who works under the direction, control, and management of a specified broker or owner developer. A sales associate must meet additional licensure requirements to become a broker or broker associate. Broker associate. A broker associate is someone who has obtained a broker license but performs real estate services as a sales associate under the direction, control, and management of a specified broker. General licensure provisions. General qualifications. Required disclosures. Reasons for denial. General qualifications. To qualify for a real estate license in Florida, an individual must be at least 18 years old, hold a high school diploma or its equivalent, and be honest, truthful, trustworthy, and of good character. He or she must have a good reputation for fair dealing and be competent to handle real estate transactions. Being a U.S. citizen is not a requirement for licensure as long as the individual meets all other requirements of licensure. However, applicants must have a Social Security number. Required disclosure. An applicant must disclose any alias or also known as AKA name. The applicant must also disclose whether he or she is under investigation for any crime or violation, has been convicted or entered plea of no contendere, no contest, or guilty for any crime, has been denied licensure or registration for a regulated profession, has been disciplined or is pending discipline in any jurisdiction, has surrendered a licensure or had a license suspended or revoked, has been guilty of any conduct that would be grounds for license suspension or revocation. Reasons for denial. An applicant may not qualify for licensure if he or she has been denied a license, had a license revoked or suspended, or has committed offenses that would be grounds for license revocation or suspension. In such cases, when considerable time has passed since the offense, or if the applicant has since demonstrated conduct good enough to assure he or she is of no danger to the public, the FREC may determine that he or she is then qualified to apply for licensure. The applicant may also be denied if the applicant acted as a licensee in performing real estate activities or presented him or herself as a licensee within 1 year prior to applying for a license. Applicants may not be denied licensure based on conviction of a crime that occurred 5 or more years prior to submission of the application unless the crime was related to the practice of real estate or related to the absence of good moral character. Application requirements. Fees, application form, background checks, application omissions, application approval, appealing denials, application validity period, non-resident applications, course requirements, education exemptions. Fees. The FREC charges fees for licensure application, examination, re-examination, licensing, license renewal, license reinstatement, unlicensed activity, the real estate recovery fund. License examination fees and fingerprinting processing fees are paid directly to the testing vendor. If, for any reason, the application for licensure is not completely processed, the application fee may be refunded. There are maximum limits set for each fee based on the estimate of funds the Commission needs for operation. In case of an excess in the funds collected, the Department may waive license renewal fees for up to 2 years. If the funds run low, the fee amount can be increased, or the FREC can charge a one-time fee from each active and inactive licensee to remove the deficit. Waivers. Florida waives the initial license fee for the following individuals: a member of the U.S. Armed Forces who served on active duty, a spouse who was married to a member while on active duty, and a surviving spouse of a member who died while on active duty. A low-income person whose pre-tax household income is at or below a specified percentage of the federal poverty guidelines based on the family's household size and proven by enrollment in a public assistance program. These individuals must pay the application fee, unlicensed activity fee, the real estate recovery fund fee, examination fee, and the fingerprinting process fee. Florida also waives the initial licensing fee, the initial application fee, and the initial unlicensed activity fee for a military veteran or the veteran's spouse if he or she applies for licensure within 60 months after the veteran has been honorably discharged from an active duty in any branch of the United States Armed Forces. These individuals must pay the examination fee, the fingerprint processing fee, and the real estate recovery fund fee. Application form. Applicants for a Florida real estate license must submit the designated DBPR application form as provided on the DBPR's website. The application must include the applicant's social security number and name as it appears on the applicant's social security card. The applicant must also submit any additional documentation required by the department, including documentation on the applicant's education, work history, criminal history, discipline, fingerprints, and so on. Background checks. Applicants for a real estate license in Florida must submit to a background check and provide their fingerprints to the DBPR. Fingerprints. Applicants may use any approved Level 2 FDLE fingerprinting live scan vendor to submit their fingerprints. When submitting fingerprints, the applicant must also submit the originating agency identification ORI number, which can be found on the www.myfloridalicense.com website. Background check. On receiving the applicant's fingerprints, the department will forward them to the Florida Department of Law Enforcement and the FBI for use in conducting a criminal history check on the applicant. Both agencies will send their background reports to the DBPR, usually within 3 to 5 days. To allow for adequate processing time, applicants should submit their fingerprints at least 5 days prior to submitting the license application. The DBPR will use these reports to determine if the applicant is qualified for examination and licensure based on the presence or lack of criminal history. Criminal history. If the background report indicates a criminal history, it is best if the applicant has already provided all associated information to the department along with the application. This is accomplished by answering all application background questions completely and honestly, and including documentation that provides detail of any investigations, convictions, guilty pleas, or nolo contendere pleas with dates, findings, and penalties. If the penalties have already been satisfied, the application should include documentation providing the satisfaction for each conviction. Any applicant currently on probation as a result of a conviction should also include an official letter from the probation officer regarding the statutes of the current probation. The applicant may also want to include at least 3 character references with the application and other documentation. One reference letter may be from a family member, but all others must be from other people who know the applicant and can attest to his or her character. Summary of applicants. If an applicant's background check indicates a criminal history, the application is placed on a summary of applicants list and submitted to the FREC for review in its monthly meeting. During the review, the FREC will determine if the applicant is approvable for examination and licensure, or if the applicant requires additional consideration and information. Additional information on digital fingerprinting and the approved vendors can be found on the DBPR's website at www.myfloridalicense.com. An applicant may order a criminal background report on him or herself on the Florida Department of Law Enforcement website at www.fdle.state.fl.us. Application omissions. If an applicant makes an error or omits pertinent information on the application, the licensing department must notify the applicant within 30 days of receiving the application. The notice is to include any additional information needed, and a time period for the applicant is to make the corrections and submit additional information. If the department does not send a notice within 30 days, they may not deny the application for the uncorrected errors or omissions. Application approval. The department must approve or deny a license application within 90 days of receiving it. If the department fails to meet the deadline, the application is considered approved by default. Applicants who are approved by default are to notify the department in writing of their intent to rely on the default approval. If the commission denies the application, it must notify the applicant in writing of the denial and reasons for denial. The notice must inform the applicant of his or her appeal rights. Appealing denials. If an application has been denied, the applicant will receive a notice of intent to deny. He or she then has the right to choose to accept the denial and forfeit the opportunity to become licensed. Petition for an informal hearing before the FREC to present arguments against the reason for denial. Petition for a formal hearing before an administrative law judge to review the denial order. An applicant who chooses to request a hearing on a denial must file a petition with the DRE within 21 days of the denial notice. Application validity period. Initial application. The initial license application remains valid for 2 years after the date it was received by the DBPR. Exam eligible. The applicant has 2 years after completing the pre-license coursework to pass the licensure examination. If the applicant fails to pass the examination within those 2 years, the completed coursework becomes invalid. Non-resident applications. See non-resident license requirements section below. Course requirements. The FREC requires applicants for licensure to complete pre-licensed real estate educational courses. These can be taken at an accredited college or university, a career center, or a registered real estate school. Each classroom hour is equal to 50 minutes, with each license type requiring a specific number of classroom hours. See requirements section below. Missing more than 8 classroom hours during the course is an automatic failure. If a student misses more than 8 hours due to student or family illness, he or she may attend makeup classes within 30 days of the scheduled end of course examination date. Classes taken after the 30 days need commission approval. Makeup classes must cover the same material as the classes missed. After completing the coursework, the applicant must pass an end of course examination with a score of 70 or higher. A student who fails the examination may retake a different form of the examination 30 days after failing. The student may retake the examination only one time during the year after failing. If the student does not pass the end of course examination within the year, the student must repeat the pre-licensed courses. When the student completes the coursework and passes the end of course examination, the school must provide the student with a certificate of course completion and notify the FREC of all students who completed the course. The FREC is required to approve distant learning courses through internet streaming or other means of video conferencing as an option to classroom hours. Students taking distant learning courses must pass a timed course examination. The pre-licensed courses must also be made available by correspondence or other suitable means for students whose hardship prevent them from attending the classroom courses and from having access to distant learning courses. The pre-licensed courses must also be made available by correspondence or other suitable means for students whose hardships prevent them from attending the classroom courses and from having access to distant learning courses. A 4-year degree in real estate from an accredited school of higher education with the coursework covering the same subject matter as required by the FREC may be substituted for the required pre-licensing courses. A pre-licensed student may demonstrate FREC approved minimal competencies that show the student is qualified for licensure as a substitute for taking specified classroom hours. Education exemptions. Persons seeking licensures who are exempt from the requirement to complete pre-licensed education include the following: an active attorney in good standing with the Florida Bar who is qualified under real estate license law may obtain a real estate sales associate license without completing pre-licensed education courses. However, attorneys must pass the licensure examination. Anyone who has a 4-year degree or higher in real estate from a school of higher education may obtain a real estate license without completing pre-licensed education courses. However, individuals with this degree must pass the licensure examination. A non-resident licensed in the state that has a mutual recognition agreement with Florida may obtain a real estate license without completing pre-licensed education courses. However, these non-residents must pass a 40-question licensure examination. Sales associate license requirements. General license requirements. Pre-license course. State license examination. General license requirements. To qualify for a Florida sales associate license, the applicant must have a social security number, receive approval of the license application, pay all required fees, meet all general licensure provisions including age, education, character, competency, submission of associated background history, and fingerprints as discussed in the previous section. Pre-license course. Applicants for a sales associate license must complete 63 classroom hours of an FREC approved pre-license course referred to as Course 1 to be taken at an accredited college, career center, or registered real estate school. The course includes the fundamentals of real estate principles and practices, real estate law and license law, and associated mathematics. The required hours consist of 60 hours of instruction either in the classroom or by the way of distant learning, and 3 hours allowed for the end of course examination. State license examination. After completing the pre-license coursework and passing the end of course examination, an applicant has 2 years to take and pass the state licensure examination. If the applicant waits longer than the 2 years, he or she must retake the pre-license course to be eligible to take the licensure examination. Applicants must reschedule or schedule the exam directly with the testing vendor and pay the exam fee at that time. Prior to taking the exam, the applicant must present the pre-license course completion certificate and 2 forms of identification, one of which is to be government issued and include a photo. The examination is given on a computer-based system that allows students to answer questions or skip questions and go back into them later. The examination is to be given on a computer-based system that allows students to answer questions or skip questions and go back to them later. It also provides a summary of how many questions have been answered, how many were skipped, and how much time is remaining on the test. The exam is available in English and in Spanish. Non-electric foreign language translation dictionaries are allowed in the exam room but must be approved by the test administrator. No other reference materials are allowed in the examination room during the test. The state examination includes 100 multiple choice questions and may include pilot questions that are not included in the final test score. The applicant must pass the test with a score of 75% or higher. If the applicant is a Florida non-resident, he or she must take the designated laws and rules 40 question examination and pass with a score of 30 out of 40 points, 75%. Failing the examination. An applicant who fails the examination may request a review of the questions answered incorrectly. The request must be made within 21 days of taking the exam and may be performed only for the applicant's most recent exam. The applicant must pay a fee for the review and is given half of the exam administration time for the review. The applicant must pay a fee for the review and is given half of the exam administration time for the review. During the review process, the applicant may challenge the incorrect answer to have it reviewed by a subject matter expert. Whether or not the applicant challenges the results of the failed exam, he or she may pay a fee and retake the exam as many times as necessary within the 2 years. There is no waiting period to retake the examination. License issuance. An applicant who passes the examination will be given a photo-bearing exam report indicating the applicant passed the examination. The applicant's score will be provided to the DBPR, who will issue a sales associate license number and provide instructions for printing the license. The license is issued in an inactive status. To activate the license, the sales associate must establish an association with a broker and then either activate his or her own license by printing the DBPR RE11 sales associate or broker sales associate become active form and having the broker sign it, or by having the broker add the sales associate to the broker's online account. The sales associate must be licensed, associated with a broker, and activated prior to performing any real estate services which require a license. The RE11 form can be found online at www.myfloridalicense.com/DBPR/re_1_change_of_status_associates.pdf. Broker license requirements. General license requirements. Experience requirements. Pre-license course. State license examination. General license requirements. Just as with a sales associate license, an applicant for a Florida broker license must meet certain general license requirements. To qualify for a broker license, the applicant must have a social security number, submit and receive approval of the DBPR RE2 license application, pay all required fees, meet all general license provisions including age, education, character, competency, submission of all associated background history and fingerprints as discussed in a previous section. An applicant who has been licensed as a sales associate in Florida during the preceding 5 years must complete the sales associate post-license education requirements as discussed in an upcoming section prior to applying for the broker license. The post-license education requirement does not apply to applicants who hold an out-of-state sales associate license. Experience requirements. In addition to meeting the general license requirements, the applicant must have held an active real estate sales associate license for at least 2 years during the 5 years prior to applying for a broker license. The applicant must also have worked under one or more real estate brokers who are licensed in Florida or any other U.S. state, territory, or jurisdiction, or in any foreign national jurisdiction. Perform real estate services as a salaried employee of a governmental agency, or been licensed in any other U.S. state, territory, or jurisdiction, or in any foreign national jurisdiction. Applicants who have gained their required experience from a jurisdiction outside of Florida need to submit a current certification of real estate license history from the licensing agency of that jurisdiction. The certificate must not be more than 30 days old and should be attached to the broker license application. Pre-license course. A licensed sales associate who is applying for a broker license must complete the required pre-license course 2. The course includes 69 classroom hours and 3 end-of-course examination hours. The course covers the fundamentals of real estate appraising, investment, financing, and brokerage and management operations. Just as with the sales associate pre-license coursework, each classroom hour is 50 minutes of live instruction in the classroom or of live streaming or video conferencing. The course may be taken at an accredited college, technical center, or registered real estate school, or through interactive distant learning. A student who demonstrates hardship may qualify to take the course through correspondence. The student must not miss more than 8 hours of classroom instruction. The broker end-of-course exam includes 95 multiple-choice questions, 90 of which are worth 1 point each, and 5 of which may cover closing statements or escrow accounts are worth 2 points each. The student must pass the exam with a score of 70% or higher to complete the course. Students who fail the exam may retake it once. State license examination. After successfully completing the broker pre-license coursework and passing the end-of-course exam, the applicant must take and pass the state licensure examination within 2 years of completing the course. If the applicant waits longer than 2 years, he or she must retake the pre-license course to be eligible to take the licensure examination. The exam for brokers is based on knowledge, understanding, and application of real estate law and real estate principles and practices, and includes appraising, finance, investment, brokerage management, and real estate mathematics. The exam is divided into 45 points based on law, 40 points based on principles and practices, and 15 points on real estate mathematics. The student must pass the exam with a score of 75% or higher. The processes for qualifying for taking, passing, failing, and retaking the exam are the same as for the sales associate state exam. After passing the state exam, the student must print his or her license. Because the license is issued as inactive, the individual must submit a completed DBPR RE 13 broker transaction form to activate the license prior to operating as a broker. Non-resident license requirements. Florida resident defined. Non-resident application requirements. Mutual recognition. The Occupational Opportunity Act. Florida resident defined. Florida statutes define a resident as a person who has resided in Florida continuously for a period of 4 calendar months or more within the preceding 1 year, or a person who presently resides in Florida with the intention to reside continuously in Florida for a period of 4 months or more, commencing on the date that the person began the current period of residence in Florida. Non-resident application requirements. Non-resident applicants must hold a license in their state of residency. To apply for licensure in Florida, an applicant must submit the appropriate DBPR application form for a sales associate or broker license along with the required fee, fingerprints, and any required supporting documentation, including a certification of license history issued by the state from which the applicant is claiming mutual recognition. Mutual recognition. Mutual recognition agreements allow Florida to recognize and accept the pre-licensed education experience obtained in the other state as a substitute for the requirements in the state where the non-resident is applying for a license. The non-resident applicant must pass a written examination on general real estate law and codes with emphasis on chapters 455 and 475 and chapter 61J2. The laws and rules examination contains 40 questions and requires the applicant to correctly answer or at least 30 of those questions. The laws and rules examination contains 40 questions and requires the applicant to correctly answer at least 30 of those questions. Only after passing the examination will the applicant be issued a Florida license. The non-resident licensee is then responsible for completing all post-license and continuing education that is required of a Florida licensee. Florida licensees may seek licensure in any state that has a mutual recognition agreement with Florida. keeping in mind that each state may have different requirements for non-resident licensure. To apply for a non-resident license, the Florida licensee should contact the other state's real estate commission. Mutual recognition versus reciprocity. A mutual recognition agreement is contracted between two states and sets forth the states will recognize and accept each other's real estate pre-license education requirements. Reciprocity is an agreement between states to allow licensees of one state to obtain a license in the other state without completing the full licensing requirements of the other state. While each reciprocal state has its own specific requirements, most do not require the non-resident licensee to pass an examination for licensure in the reciprocal state. Florida currently holds mutual recognition agreements with several states but does not have reciprocity agreements with any states. The Occupational Opportunity Act. Although Florida does not have reciprocity agreements with other states, the Occupational Opportunity Act, in parentheses, FL House Bill 615, as amended in Chapter 2017 through 135, close parentheses, mandates that Florida provide reciprocal licensure for military members, their spouses, their survival spouses, and low-income individuals. The Act covers all professions regulated by the DBPR, including real estate. The purpose of the Act is to make transfers to Florida easier for military members and spouses who hold licensees in the same profession in any other state. To qualify under the Act, military members must either be currently on active duty or have been honorably discharged. Surviving spouses qualify and the military member was in active duty at the time of death. Proof of the member's active duty must be submitted at the time of application. Applicants must be licensed in good standing in other state and must submit fingerprints for the background check at the time of application. The Act waives initial licensing fee, but the applicant must pay fingerprint fees. The Act also waives requirements for pre-license education and examination, but the license must meet all renewal education and fee requirements. Reciprocity is available for up to 2 years after discharge from active duty to those who qualify under the Act. License information, registration. License information, registration. License information. Identity, contact information, license type, and number, dates. Real estate licensees issued in Florida include the licensee's name and address, type of license, license issue and expiration dates, and the license number. The license number includes a 2-letter prefix that indicates the type of license. BK for broker, SL for sales associate, BL for broker associate, BO for branch office, CQ for corporation or limited liability company, or PR for partnership and limited liability partnership. Prima facie evidence of currency and validity. The license serves as a prima facie evidence that the individual holds a current valid license. Prima facie evidence is defined as evidence that at first view is good and sufficient on its face to establish a given fact or to prove a case. Unless the evidence is contradicted, it proves a case or, as in the case of licensure, proves the license is valid. As discussed throughout this section, real estate licensure is obtained by meeting all state requirements, including completing education and examination requirements, submitting to background history checks, paying applicable fees, meeting general age and character requirements, and so on. When the individual or entity has met the requirements, the state will issue the license that allows the licensee to perform real estate services for compensation. The license must be timely renewed to allow for continued performance of real estate activities. Registration. Every person or entity who is licensed is required to register with the FREC, pay a registration fee, and submit all required information. Name and address of the licensee, name and business address of sales associate licensees employing broker, license status of the sales associate and his or her employing broker, and whether or not the licensee is an officer, director, or partner of a real estate brokerage. Registrations must be renewed when the license is renewed. Florida sales associates and broker associates are required to register under the employing broker and can only register under one broker at a time. Partnerships, limited liability partnerships, limited liability companies, and corporations that act as brokers must register. Partnerships are required to license and register at least one partner as an active broker. Real estate brokerage corporations must license and register their officers and directors. Brokers must also register all branch offices. If a licensee changes names or trade names, the license must be reissued in the new name and re-registered. Trade names are to be shown on both the license and the registration. License renewal education, post-license requirement, continuing education, reactivation education, post-license requirement, course completion. All sales associate licensees are required to complete a post-licensing course before the first license renewal, even if the license is inactive. The course is 45 classroom hours and includes an end-of-course examination. The course emphasizes development of skills for licensees to operate effectively and to increase public protection. Any sales associate licensee who applies for broker licensure must have completed all sales associate post-license requirements. All broker licensees are required to complete post-license education, which includes either one 60-hour course or two 30-hour courses and the related exams. All post-license requirements must be met prior to their first broker license renewal date. The course is to be taken at an accredited college, technical center, registered real estate school, FREC approved sponsor, or through a distant learning program. A licensee who is absent from more than 10% of the classroom hours would not be given credit for completing the course. The licensee must pass at the end of course exam with a 75% or higher score. Exam failure. On failing the course exam, a licensee must retake the exam 30 days after failing. The licensee may retake the exam only one time during the year after failing. A licensee who does not pass the exam within that year must then repeat the post-licensure course. If the licensee does not complete the post-license course and pass the exam prior to the first license renewal date, his or her license will be deemed null and void. To requalify for licensure, the individual must retake the entire pre-license course, pass that end-of-course exam, and again pass the state licensure exam. However, a broker who does not meet the broker post-license requirement may be issued a sales associate license by completing a 14-hour continuing education course within 6 months of the expiration of the broker license. Exemption. Licensees who hold a 4-year degree in real estate from an accredited Institute of Higher Learning are exempt from post-license education requirements. Hardship cases. The FREC may allow a 6-month extension past the first license renewal date for a licensee to complete post-license requirements if the licensee cannot meet the education completion deadline due to a personal hardship. The FREC Administrative Code qualifies the following as hardships: the long-term illness of the licensee or a close relative or a person for whom the licensee has caregiving responsibilities, the lack of reasonable availability of the required course, the licensee's economic or technological hardship that substantially interferes with the ability to complete education requirements, the licensee's economic inability to meet reasonable basic living expenses. To obtain the time extension, the licensee must submit a written request to the Commission explaining the basis for the alleged hardships and submit any documentation the Commission requires as support and or proof. Licensees may also claim a hardship to be allowed to complete post-license education through correspondence if they cannot attend the classroom course or do not have access to distant learning courses. Continuing education. Course completion. Florida real estate licenses are issued for 2-year periods requiring renewal every 2 years. During the initial licensing period, licensees are required to complete post-licensing education based on the type of licensing held. During the same initial period, licenses are not required to complete continuing education, but continuing education is required for every 2-year licensing period thereafter. During each licensing period, both active and inactive sales associate and brokers are required to complete 14 classroom hours of continuing education that must include at least 3 hours of core law education. Continuing education courses may be taken in the classroom, through distant learning, or by correspondence. If the licensee qualifies for a hardship, the licensee must attend at least 90% of each of the classroom hours to receive the notice of completion. The DBPR may deny license renewal for any licensee who fails to complete continuing education requirements. Failure to provide proof of continuing education or providing false proof are grounds for disciplinary action. Course credits. Because core law covers Florida real estate license law, commission rules, and agency law, and provides an introduction to other state laws, federal laws, and taxes affecting real estate, it is advisable for the licensee to take a 3-hour core law course every year to stay up to date on the laws and rules. Any licensee who does take the course each year will be awarded 3 hours of core law education and 3 hours of specialty education. Any licensee who does take the course each year will be awarded 3 hours of core law education and 3 hours of specialty education. Licensees whose licenses expire after September 30, 2018 also required to take a 3-hour business ethics course every license period. Licensees who take the business ethics course each year will be awarded 3 hours of business ethics education and 3 hours of specialty education. The remaining hours required towards the 14 hours may be taken in specialty education courses, also known as electives. One time during each license period, the licensee may be awarded 3 classroom hours for attending an FREC legal agenda session. To receive the credit, the licensee needs to notify the Division of Real Estate of the intent to attend the session. No credit will be awarded if the licensee attends the session as a party to a disciplinary action. The courses must be completed by either March 31st or September 30th, based on the license expiration date. A 6-month extension past the renewal date may be available if the licensee cannot meet the education completion deadline due to a personal hardship. Exemption. These continuing education requirements do not apply to attorneys in good standing with the Florida Bar. Reactivation education. A licensee who has been on involuntary inactive status for 12 to 24 months may complete an FREC prescribed 28-hour education course toward reactivating the license. The course covers material from the Sales Associate Pre-License course. The course may be taken in the classroom, through distant learning, or by correspondence if the licensee qualifies for a hardship. Completion of the course does not entitle the licensee to reactivate the license until he or she has met all other requirements. The licensee must also pass the end of course exam with a score of 70% or higher. Licensees must attend a minimum of 90% of the instruction hours to be eligible to take the exam. Licensees who failed the exam may retake it one time within a year of failure. If the licensee fails to retake the exam, he or she must retake the reactivation course and the end of course exam. Licensees who meet the qualifications of a hardship may request a 6-month extension after license expiration or submitting the hardship basis to the FREC. Activities requiring licensure. Exemptions. Individuals required to be licensed. Individuals exempt from licensure. Individuals required to be licensed. Individuals who perform real estate services for compensation or the expectation of compensation must be licensed as real estate sales associates or brokers. As noted earlier, real estate services that require licensures include the sale, exchange, purchase, rental appraisals, auction, and advertising of real property, business enterprises, and business opportunities, and the offer to perform any of these services. Services include procuring sellers, buyers, lessors, and lessees. Individuals exempt from licensures. The following individuals are not required to hold a Florida real estate license: owners who sell, exchange, or lease their own properties, corporations, partnerships, trusts, joint ventures, or other entities or officers, partners, or directors of entities that sell, exchange, or lease their own properties, unless an agent, employee, or independent contractor is employed and paid by the entity on a transactional basis to sell, exchange, or lease property. However, partners must be licensed if their percent of sale profits are higher than their individual percent of ownership in the business. Any person acting as an attorney in fact who is authorized to act in another person's place to execute contracts or conveyances. Any attorney at law performing his or her duties without being compensated for performing real estate services. Any certified public accountant performing his or her duties. Any personal representative, receiver, trustee, or general or special magistrate appointed by a will or court order. Any trustee acting under a deed or trust agreement. Any salaried employee of an apartment community who works in an on-site rental office to lease apartments for any time period and who is not paid on a transactional basis. Any apartment community tenant who receives a referral fee of $50 or less for referring a new tenant to the community. Any salaried manager of a condominium or cooperative apartment complex who handles individual unit rentals for periods of 1 year or less, not paid per transaction. Any owner-occupant of a timeshare period selling the period. Any licensed or certified appraiser performing appraisal duties. Any person or entity who is paid to rent or advertise for rent transient lodgings such as hotels or motels. Any dealer registered under the Security and Exchange Act who sells, buys, exchanges, or rents business enterprises to accredited investors. Any employee of a real estate developer who is paid a salary but not paid on a transactional basis. Any individual who rents lots in mobile home parks or recreational travel parks. Any individual who sells cemetery plots. 2. Real estate license law qualifications for licensure snapshot review. History and purpose of real estate license law. History of Florida's real estate license law. Chapter 475 passed in 1923 as first Florida real estate law. FREC created in 1925. Purpose of regulation. Protect consumers. Caveat emptor overturned in 1985. Sellers must disclose property defects even if not asked. Important Florida real estate statutes and rules. Several enacted to protect consumers and to allow qualified individuals to enter real estate profession. License categories. Broker. Licensed to perform real estate services for compensation. Real estate services. Sale, exchange, purchase, rental, appraisals, auction, advertising, procuring, sellers, buyers, lessors, or lessees. Sales associate. Licensed to perform real estate services under direction of broker. Broker associate. Same license as broker but works under direction of broker. General licensure provision. General qualifications. 18 years old. High school education. Good character. Competence. Social security number. U.S. citizenship not necessary. Required disclosures. Disciplinary or criminal history. Aliases. Reasons for denial. Previous license discipline. Perform real estate activities without a license. Application requirements. Fees. Several fees charged, some waived for military members and veterans, spouses, and surviving spouses. Application form. Must use DBPR form. Submit additional documentation. Background checks. Submit to background check. Provide fingerprints. Provide information about criminal history. Omissions. Applicant to be notified within 30 days of errors and omission on application. Application approval. DBPR to approve or deny application within 90 days of receipt. Applicant has right to appeal denial. Appealing denials. Accept denial. Petition for informal or formal hearing to challenge denial. Application validation. Application valid for 2 years. Pre-license course valid for 2 years for pre-licensure exam. Non-resident applications. Detailed later. Course requirements. Applicant to complete courses with 8 or fewer misses, to pass end of course exam with 70% score, to retake once in a year. Courses to be taken at school. Distant learning, correspondence if hardship, 4-year degree, substitutes for pre-license course. Education exemption. Exempt. Attorneys, those with 4-year real estate degrees, those with mutual recognition agreement. Public records. Made or received in accordance with law or ordinance in official transaction. Sales associate license requirement. General requirements. SS number. Application approval. Fees paid. Meet age, education, character, competency, background requirements. Pre-license course. 60-hour course, 3-hour exam with 70% pass score. State license examination. Within 2 years of course completion, pass with 75% score, print and activate license. Retake failed exam unlimited times, may review incorrect answers. License issued in inactive status. License must be associate. with broker before performing services. Broker license requirement. General requirements. SS number. Application approval. Fees paid. Meet age, education, character, competency, background requirements. Complete sales associate post-license education. Experience requirement. Active sales associate license for 2 years within past 5 years. Worked under broker. Pre-license course. 69-hour course and 3-hour exam with 70% pass score. State license examination. Within 2 years of course completion, pass with 75% score, print and activate license. Retake failed exam, unlimited times, may review incorrect answers, issued as inactive, activate by filing form. Non-resident license requirements. Florida resident defined. Reside in Florida for 4 months or intend to continue to reside for 4 months. Non-resident application requirements. Hold license in resident state. Submit certificate of license history. Meet Florida application requirements. Mutual agreement. Agreement of Florida and another state to recognize other states' pre-license education and required laws and rules exam. Reciprocity allows one state's licensees to obtain another state's license without meeting all requirements. Florida has no reciprocity with other states. Occupational Opportunity Act. Reciprocal license for military spouses, surviving spouses, low income license in another state, pre-license course and exam waive. License information registration. License information. Identity, contact, license type, number, dates. License serves as prima facie evidence of valid licensure. License issued after applicant meets all requirements. Registration. All licensees to register with FREC, sales and broker associates to register under broker. License renewal education. Post-license requirement. Sales associate, 45-hour course and end of course exam with 75% pass score. Brokers, 60-hour course and end of course exam with 75% pass score. Continuing education. 14 hours every 2-year license period to include 3 hours of core law and 3 hours of business ethics. Reactivation education. Involuntary inactive status for 12 to 24 months can reactivate with 28-hour course and exam with 70% pass score. Activities requiring licensure. Exemptions. Individuals required to be licensed. Anyone who perform real estate services for compensation. Individuals exempt from licensures. Owners selling owned property. Attorney in fact or at law. CPA, trustee, certain paid employees, timeshare owner occupant,